45 minutes. The rules for notice, and the defendant had notice. Matter of fact, they had notice before the state had notice. You indicated yesterday you thought it was a technical violation. We respectfully disagree. We found no cases where there had been this kind of scenario where the defense knows the statement, we don't know the statement, and then we learn it later. But we did find this soliciting case, which we provided to the court, which is 717 Southern 2nd 205 1998 case. In that case, apparently an officer had not put in his report a statement made by the defendant, but he gave it in the deposition. So the state did not provide the defense, here's a statement not in a report by the defendant, because they already knew it. The case says the defendant put this through, the defendant was aware of the statement prior to trial, therefore it's not a Richardson violation, not a discovery violation. They knew about this statement prior to trial. It is not a discovery violation or Richardson violation. The rule is for them to know. They knew. They knew before we did. So they are claiming possible prejudice. We think we or the court should be able to voir dire their experts. At least one of them knew about it beforehand, before they testified, to see what they knew about it, and would it affect their opinion. To deny the admission of the statement is the most extreme sanction. The defense court can be allow the defense to reopen their case or put out sort of rebuttal on the issue. They can truthfully claim that this is new evidence that came up during the trial, and their experts are not going to say it changes their opinion. At least one of them, it doesn't change their opinion because he knew about it before he testified. So we know at least one of them it won't change their opinion at all. The rules are designed.
Well, who knew about it before they testified?
She said one of their doctors. I can't tell you which one.
Okay.
But one of their doctors did before they testified. The rules are designed to give the defendant notice. They got notice. The rules are not for the gotcha moment. They made a strategic decision to move forward on this case with the hope that we wouldn't find out about those statements in the phone calls. When their strategic decision went south, they should not now allowed to be called surprise and prejudice. The strategy to proceed with hopes of us not finding out about the statements doesn't make them victims in this matter. Their strategy decision does not turn this into procedural prejudice. They hoped we would never find out. The rules are to prevent gamesmanship. They were hoping that we wouldn't find out. We found out. Now they want to claim victim and they want to claim foul. They shouldn't be allowed to do so. There was no discovery violation. They were fully aware of it. They made a strategic decision to proceed the way they did. When that strategic decision backfired on them, because we happened to find out about it, because Ms. Malcolm called us, they should not be now allowed to benefit from that. And Judge, I was handed a case, Eaton, 868 Southern 2nd, 650, 2004. The extreme sanction of excluding evidence should only be used as a last resort. There are ways to cure this. The defense could be allowed to sit in through Ms. Kirsten's testimony, as we've allowed our experts to watch other witnesses' testimony, for instance, Ms. Torres. They could be allowed to watch that, and then they could be called to comment upon that testimony. They could reopen their case and present those experts. They could do them in sur rebuttal. There are ways to avoid the prejudice that is hypothetical at this point. There's been no evidence that their experts were going to change their opinions or there's going to be any prejudice to them. It's a hypothetical situation, which is why we're requesting that we're dire the experts to see if they know about it. One would assume, once they learned this evidence, that they talked to their experts about it. And if they didn't, then at least one expert knew, and if they didn't, then their experts can consider that and make the proper ruling on this. Judge, the courts in Florida have held that the criminal rules are designed to prevent surprise by either the prosecution or the defense. The purpose is to facilitate a truthful fact-finding process. They were hoping we didn't know that fact. They were hoping we would never find out about that fact. And when we did, they now can't claim prejudice and foul and surprise. There was no discovery violation. The rules are they have to know what is going to be said and who said it. They knew that. Whether it comes from us or another source, they knew that. So just like the case in the deposition, they knew it before it came in trial, they knew it before now. They can't now claim procedural prejudice because their strategic theory and move and presentation backfired on them.
Let me ask you this. What about their argument that you can't use it because you didn't notice them that it existed, even though they knew it existed? They presumed you weren't going to use it because, and I agree, it doesn't really matter whether it's slick or ambushed, you're looking at the rules, because you didn't follow 3.220C. Because I think that's going to be their argument.
Judge, the rule isn't that the state has to know it. The rule is that they have to know it.
Well, this rule says any written or recorded statements and the substance of any oral statements made by the defendant. And it doesn't say anything about if they don't already know it.
But they knew it. Well, that's what in the listing case, they knew it too, because it was in a deposition and the state never gave that notice under 3.220. The state never gave that notice, and they said that is clear that they already knew it and it's not a discovery violation. That's as close as we're going to get, because there is no case that's going to be found under this situation because it's not a discovery violation.
Okay, response?
Judge, the discovery violation occurs when the rule isn't complied with. We are now having a Richardson hearing, or had the Richardson hearing yesterday, continuing argument regarding the 3 prongs because a discovery violation happened. The violation occurs when the rule isn't followed. The rule wasn't followed. And so now the issue is whether it was inadvertent or willful. I would suggest that it was willful if the state is indicating they got this information on Monday, they are of the belief that one of our testifying experts was aware of it, and then they cross-examined all 3 of our experts and didn't ask a single question about it. I would suggest that it was intentional, that they were intentionally not putting us on notice about it. They certainly crossed them about the other statement that we have contested and argued about, and they intentionally didn't ask any of the experts about that statement. And so, more importantly though, it's the prejudice. Regardless, even if it was inadvertent or willful, it's certainly substantial. The court, I believe, already made that finding yesterday. And it's already resulted in prejudice. There is no way for us to, we don't just go to our experts with every piece of evidence, obviously. The court knows that. We take them information that they need to consider informing their opinion. If we had information or believed that it was going to be evidence that was taken into consideration at trial, or that the state's experts was going to be provided, we would have certainly discussed that with them before calling them to the witness stand and having them render an opinion in the case. There's no way for us to fix the issue now. Like I said, there's the extreme possibility of one of our experts saying that they changed their mind, if they would change their opinion. But even if we were to call them in rebuttal, then it's certainly, I mean, there's not a chance that it's not going to be insinuated or give the appearance that these people didn't have all the information when they testified. And that's not fair, it's not true. When the state had those oral statements, the rule says they have to give us those oral statements. They had not cross-examined a single one of those witnesses yet. They could have provided us those statements, called a timeout, let us talk to them, and this could have been cured. But it wasn't provided then, and at this point we've rested our case. And so I think the prejudice is great at this point, and I don't think there's a way to cure it by allowing this evidence in.
What is your response that it's not a discovery violation? Oh my, I'm surprised. When you obviously, I guess your position is we weren't surprised at her testimony, we're surprised that they're going to use it.
Correct.
Okay. Do you have anything that says that?
There is, well, all of the things that the cases that the state provided show that well, the Brown case that from yesterday that I cited, where's my computer? But specifically in the case that the state provided, what's noteworthy here is they never objected. So there was never a hearing. So there's no discussion at all about the prejudice. And certainly the complete lack of mention of it would suggest that there was none. It was a statement that they were in a deposition together, the state and the defense, and they knew the statement was out there.
Well, the statement's pretty prejudicial. I should have killed her.
Right, but he had it in a deposition, and a deposition is where the state's present and the defense is present. So the state knew that the defense knew that the state was aware of the statement. Everybody's on notice that the statement is likely to come in because everybody's been present when the statement is discussed. If the state were to call me and say, I have a statement from witness X, and I say, oh yeah, really, I talked to witness X too. That is absurd to think that would be the end of the discussion. We would obviously say, what did witness X tell you? What did they tell you? Because you don't just say, well, I assume that they talked to him so they have the exact same knowledge I have. That is ludicrous. And so there's no way at this point, I mean, they said that they could easily come in, discuss with us the statement, told us that, hey, we talked to Kirsten, there were some phone calls, are you guys aware of these? And they do know about the rule, Judge, because they provide us other statements in this case in accordance with the rule.
Well,
Officer Carter came in, gave them some statements the defendant had said in Invest and subsequently, and the state did the appropriate thing and immediately reached out to me and let me know there's some additional statements that Mr. Jonchuck made.
well, I think in this particular case, I don't think it was a willful violation. So they could get a heads up on you, because as I said yesterday, that would be really stupid given the situation that we're in. So I don't think so. Do you have, to me there's two issues here. One, is it a discovery violation if you know the contents of what we're discussing? Is
Yes.
it or is, okay.
Because the discovery
Well,
violation...
let me tell you my other question. And do they have to notice you of a statement that you already know about? So I think those are the two issues. Mr. Ellis, same thing?
It's not a discovery violation. The rule is that they know about it, and the rule requires that they know what the statement is and who's going to say it. They knew what the statement was and who was going to say it. That's what the rule requires. The cases that they are citing are, or in this case, Officer Carter, that was something they did not know. If they do not know, we tell them. But if they know, we should have to tell them. In this type of situation where in the middle of the trial, the witness contacts us and says, I talked to the defense for 45 minutes, I told them all of this, they know that. So we, as our opinion, we submit to court, it's our opinion, this is not a discovery violation. And I'm sorry, what was the second question?
If you're going to use the statement of the defendant, do you have an obligation, even though they know what it is, to provide it to them? Police report, report summary, any of those things, even though they know it. Do you have to say, okay, look, here it is?
Again, that goes with the discovery type of situation, and I think it's the same kind of argument. They knew about it. We told them we were going to call the witness. We called the witness the next day. After we told them, and we told them we were going to call that witness about 48 hours after learning about that witness, and they had known about that witness at that point for 3 weeks to a month. They can't claim surprise or prejudice or procedural prejudice when they knew this.
Judge, that would be the equivalent of them saying, we don't have to tell you about any of the defendant. I mean, operating under that theory, they would not have to relay any of the defendant's statements to us because they could just say, well, you're his lawyer. I'm sure you asked him what happened. Of course you know what he said.
And that's the point, Judge.
And that is obviously not what we have the discovery rules for.
And that's the point, Judge. If they don't know, we have to tell them. They knew. They played hide the ball. They got caught, and now they want to claim victim.
Further to.
Well, I don't necessarily disagree with all that, but I don't know that that really matters in the final analysis.
It matters that it's not a discovery violation.
It does. The violation is the not providing it. The court then does the analysis for the Richardson hearing, the 3 prongs. The violation is it not being provided. Under the state's reasoning, they would have, we would, every time we get a client, we would say what happened, get their statements, and then to have to divulge attorney-client permission to make sure those are the same statements the state has.
I know what the argument is, I just don't know. I can't remember my password on Westlaw, I have it in my office. Okay, we'll take, 10-minute recess, see what I find.
All right.
I've looked at many Florida discovery cases and Richardson's hearings, and I cannot find one case that deals with this issue. All the cases are the prosecutor.
Oh, I was just, I have some.
Okay, let's
That's what I-
see them. Let's
okay.
see them. All
Rainy,
these are the defense didn't know.
okay.
Every single one. They didn't know.
And Brown v. State, that's 165 Southern 3rd 726.
Is that the case where they didn't give the statement in the subsequent case?
That one, it's a video, right, it's a video confession regarding 2 sales, and it was listed in one of the sale cases. They were in trial on the other sale case, and they said the fact that they were aware of the statement and it had even been provided in discovery in another case did not meet the requirement, and they found that it was reversible error. I'm sorry, I moved on.
Is that the fourth DCA case?
Yes.
Okay, yeah, 'cause I got that.
And so that one obviously was a situation where they were aware of the statement, and in fact, it had actually been complied with in discovery in another case, and they still said, let me find the language. It said, in the instant case, the state committed a discovery violation, discovery violation when it failed to list defendant's video statement to police and its discovery submissions in this case. Florida Rule of Criminal Procedure 3.220 requires the state to provide names of witnesses present when recorded or unrecorded statements are taken from or made by defendant, and to provide any written or recorded statements made by defendant together with the names and witnesses of the statement. A defendant is entitled to rely on the accuracy of the information disclosed by the prosecution pursuant to a discovery request under 3.200. The failure to give all of the required information is a discovery violation. Moreover, the fact that the existence of the statement was previously revealed to the defendant does not mean that the state complied with the discovery rules. In that case, I'm going to cite to it cites to a case, and I'll get to that one next. It says a defendant is procedurally prejudiced, excuse me, if there is a reasonable possibility that the defendant's trial preparation or strategy would have been materially different had the violation not occurred. Trial preparation or strategy should be considered materially different if it reasonably could have benefited the defendant. And so in that case, it was actually provided in discovery. It was 2 drug sales that he was arrested at the same time for, and the content of the statement was regarding that he had sold drugs at that Burger King on 2 different locations. So I think that's a lot more than we have in this case. And they said that that was not okay. Then looking at DR v. State, that's 588 Southern 2nd 327. That's 4th DCA from 1991. And that one, they're in trial, and a statement is elicited that had not been provided, and the state said, well, we mentioned this statement at one of the hearings, so the defendant was on notice because we mentioned the statement, and the court said that did not satisfy the requirement. It said that the state contends on appeal that the defendant was aware of the existence of the statement Dotson gave to the police because it was mentioned during a waiver hearing less than 1 month before trial. It also points out the substantial evidence against the defendant. The state then argues that any error was harmless. The state's argument must fail. The fact that the existence of the statement was previously revealed to the defendant does not mean that the state complied with the discovery rules. It goes on to state what the rule says. Had the state an affirmative duty to disclose to defense counsel the existence of Dotson's statement and allow him to inspect, copy, test, and photograph the statement. They failed to do so. Whether the existence of the statement was later revealed at the waiver hearing does not alter the Richardson inquiry requirements when a discovery violation has been alleged. And then there's looking at Rainey v. State, 596 Southern 2nd, 1295. That's a second DCA case from 1992. That is specifically regarding an NGRI defense. The witness was listed. No statements were provided. The state responded that the defense was aware, or that the witness had been listed for a long time and had an opportunity to depose them. They said that that did not cure it, and actually went so far as to, let me pull up the language real quick. It said the trial court commented that the testimony might be prejudicial, but it was not grounds for a mistrial. We disagree. The appellant had a strong insanity defense, which was completely undermined by this discovery violation. We believe there was no remedy other than a mistrial, and the trial court erred in failing to declare the mistrial.
Can I see that?
Yes, ma'am. This one, the Rainey case is insanity, doesn't reference that the defendant had prior knowledge of the statement, though.
Judge Downey. That's not really what we have here.
Did you want me to pull either of the other ones?
Well, if you think they're relevant, I mean, I got that.
Okay. Here's the DR.
What about the Celestine case? The paragraph.
Well, I think the issue is that if we take just, one point of law in a vacuum, but we have cases that have facts analogous to ours, and so it seems...
Go ahead.
Well, I mean, the facts where the defense is aware of the information, but the discovery rule was violated. And so the whole point is that the trial preparation and strategy would have been different. The state continued to use the phrase in their argument that because their presentation backfired. They are acknowledging that we are now prejudiced. Their presentation backfired. How many times did Mr. Ellis just say that? They are acknowledging that we are prejudiced now. And so in the Celestine case, there's nothing to suggest that defense has the burden of proof in this case. The statement is, they concede that it was taken in a deposition where they were both made aware, and there's nothing to suggest that it was nearly as prejudicial as where we are here. We have the burden of proof in this trial, Judge. And so it's, I would argue, even more prejudicial than in a regular case where we don't have anything to prove.
Mr. Ellis, did I hear you right? Are you suggesting, before I make a ruling, that the defense experts should be proffered as to how that would change their testimony?
Yes, Judge, I think that it should be more dire regarding, do they know about the statement? If they don't know about the statement, get that statement, consider that statement, and how that statement would affect them.
I think I need to do that.
Well, Dr. Otto's in Atlanta.
Can he be reached by phone?
I think he's teaching a conference. I don't remember, what
Well,
was
I
that
mean,
conference?
yeah,
No, it was
cell
a
phone.
training the other day. I mean, I can try
These
to.
people at I mean, I think that's the wise course of action. I don't think it's clear.
So, I
Other
mean,
than
well,
this paragraph right here. None of these cases are right on point with the situation we have here. And I have to weigh the prejudice, and I have no idea what the prejudice is gonna be.
Judge, we have a case in Brown. It is a recorded statement that the defendant admits to 2 crimes. He is arrested for those 2 crimes at the exact same time. He admits to committing the 2 crimes in that statement. That statement is listed as actual discovery and provided to the defense in the other case. The one case going to trial, they go to introduce it. They say that could have, there's no way we can't say that it wouldn't have affected their trial strategy.
Again, Judge, that's something that the state knew about beforehand. We didn't learn this in the middle of trial.
I understand.
But they learned it prior to cross-examining our 3 experts and prior to
I
us calling
understand
you.
that. I think the wise course of action is to take Mr. Ellis up on his suggestion and see.
Oh, the only thing is obviously we would request an hour or so to
Well,
try
I
to get in contact
understand.
with them and discuss it.
You don't have any problem with a cell phone?
No, Judge.
Okay, so just however they can be reached.
Right, but we need time to consult with them, obviously.
I understand.
First, okay.
Okay. So,
I think they're entitled to whatever time they need, Judge. I'm not asking them to be rushed.
okay. I am.
I appreciate that, Judge, but on the record, it was,
And Iberia is the only case that comes close to, I understand the Brown case, let me find that Iberia case again, addressing the, I don't even know.
Do you want,
I'll find it somewhere. Well, I think we gotta do the proffer or voir dire or what anybody wants to call it. So, let's talk about what to do now, how long. There's nothing else you can put on, right?
we're getting ready to put on experts.
Right, okay.
I don't think that that's deal with issues resolved.
1 o'clock? It's 2 hours.
Well, we'll each take an expert and we'll do our very best.
Well, let's do more than that.
Do everything within my powers.
Because that's 1 o'clock? I think that's the best as we can do. I don't think it could be any sooner.
no, I certainly don't think it could be any sooner. My thought was, should we send the jury home? We come back at 1 to do the, I mean, because they want to do proper testimony. So then we come back at 1 and then we're going to do how many hours of testimony? I don't know.
I know I'm in charge, but what do you think?
That's not really a reasonable request, but again, let's leave it up to the court.
All right, I think I need to send them home. Rather than never really been sitting there for an hour and a half. Let's have them come in, please. And then Monday, we can start at 11 in the morning.
11?
Negative. Jury's in the jury box and seated, Your Honor.
Thank you. Good morning, ladies and gentlemen. The issue that arose just as we started Ms. Malcolm's testimony yesterday has become complicated and difficult. We've been in here since 9:30 this morning dealing with it. We're going to have to deal with it again this afternoon, and there's no point in you all sitting here. So, you have today off. And be nice if you knew that before you got to the courthouse. And Monday, I have a morning calendar, and we're going to start the trial at 11 o'clock. Okay? Any questions or comments or anything? No? Thank you.
Thank you.
Have a nice weekend.
Have a good weekend.
Thank you.
Yeah.
Jury's at the hearing in court, Your Honor.
There's another case I pulled. It's a United States Supreme Court case from 1988. And it's, the lower court precluded the defense witness because of a sanction for violating a discovery rule, which is different than a state witness. But it talks about ambush and fairness and integrity, search for the truth, and the harshness of excluding testimony because of a discovery violation, if there's some other way to remedy it. My belief is the testimony is very damaging to the defense, and I think equally that testimony to exclude it would be very harsh to the state. So if there's any way possible, I'm going to try to find it. Okay, but if I can't, I can't.
We kind of cite for that.
Taylor v. State, 108 Supreme Court, 646, 1988. It's really not on point except for the verbiage in it about, but I don't think it really probably has any relevance to the situation. Anything else anybody wants to say?
Your Honor, I was just suggesting to Mr. Bolin, I was taking notes yesterday, of course, during Ms. Malcolm's testimony. I don't know that I have it exactly accurate. I don't know if it might be of benefit.
I took good notes.
Okay, well, may I compare? Or I could ask,
Well,
if
let's
we
do
could
that
have it
later.
read back or something.
Well, I think we all pretty much agreed that the 2:30 phone call was the huge
No.
problem.
Our question is, in other words, we have to give that information to our experts, so we just want to make sure we're giving.
Oh, you mean all the phone calls? Or
Well-
just the 2:30 phone call?
Particularly the 2:30.
Right, I think that's the big issue.
Yeah, so I just want to make sure that when we're reporting to our experts.
Well, my notes say that, he called, he doesn't know what to do, I don't know how I can live without her. If I can't have her, nobody can. That's basically what I have.
I was missing one phrase, I don't know how I can live without her. And I also had in my notes that he said something about protecting her from this craziness.
That I don't know, I didn't write it down.
You guys have that?
Got that
That was
statement?
one of the calls, I don't remember which call, I mean.
Can you do a read back of her testimony?
I'm gonna have time to review it for a few minutes.
Huh?
I have a few minutes to review it.
You just do a rough one.
Let me find it. I don't know.
Okay.
Yesterday pulled up.
It was just.
It was the end of the day before they went home.
Yeah, just after 4:10.
We figure out which file it would be.
I just want to make sure we're okay. I don't know.
Which phone call are you specifically referencing?
The fourth one, 2:30.
Okay. About 2:30, what was the contact of that call? He was very down at that point. He was explaining that he didn't know what to do anymore. He wanted to protect her from this craziness, you know. I don't know what I would do without her. If I can't have her, then no one else will. Is that the one?
Yes.
Okay.
Do you want to do it again? You want her to do it again?
Yes, please, a little bit slower.
I'm sorry.
I had something out of order. Oh, that's unusual.
Okay. He was very down at that point. He was explaining that he didn't know what to do anymore. He wanted to protect her from this craziness, you know. I don't know what I would do without her. If I can't have her, then no one else will.
I don't know.
What I would do without her.
What?
If I can't have her, then no one else will.
Read that again. I do not know how.
Wanted to protect her from this craziness. I don't know what I would do without her. If I can't have her, then no one else will.
Okay. Okay, anything else as far as what you need?
If we are unable to have somebody here at 1, do you want us to call
Sorry.
chambers ahead of time, or, I mean, we should probably be able to have somebody here, I just don't know that everyone will be
Well,
available.
let's reconvene at, we'll say 1:15 and just see where we are. Okay?
Okay.
All right.
And if we can have witnesses here, you want
That's,
them here?
yeah, or on the phone, yes. Okay, anything else?
There.
Just one.
Judge, can we waive Mr. Jonchuck's presence for
Of
this
course.
afternoon?
Is that what you want, Mr. Jonchuck?
Yes, ma'am.
Okay. Sure. Okay.
All right. We'll be recessed till 13.